So here we are, the waning hour and a half or so of the conference, and I wouldn't want the race to the finish line to prevent us from properly thanking Ted and the brilliant panelists from doing this symposium today. It has been great, and I know that Ted has been living and breathing this for the past, I would say 4 or 5 months or so. And I can't tell whether that was a wince or something else. But we're grateful to you and to all the speakers. This last panel is a great panel. It features Irit Mavorach, who is a senior counsel to the World Bank and a member of the University of Nottingham Law Faculty, and Gabriel Moss, QC, who I think has been involved with every significant cross-border bankruptcy case that has unfolded over the past 25 or more years. And what do you think, Gabriel? And who has also taught from time to time. And Don Bernstein, who is head of the Insolvency and Restructuring Department at Davis Polk, and whom I have told over and over again should have been a law school professor, because he really would have been great. He really would have been great as a law school professor. For the students in the room, how many of you have actually read the Maxwell opinion? I want to tell you a little bit about it because to some extent it recaps and it also sets the stage for what's going to be discussed this afternoon. It has been mentioned 3 times, and it is a seminal case, an important case. So let me do it very quickly so that we can get to the main event. So it's 1991. How old were you in 1991? 4, 5, maybe? Yeah, that's what I thought. So you don't know about this. Do you remember something called the Macmillan Publishing Company? You surely know the Daily News, and something that you don't know about is what I think was called the Airplane Digest.
Airline Guides. LAG.
Yeah. So when you would call, you wouldn't do it online. You would call to make an airline reservation, and you would hear pages rifling. They were going through the agent was looking at 1,000-page paper, paper. Dead tree directory, looking for flights and connecting flights, and it was really quite an ordeal. And it was also a very big business. And Macmillan and the airline publishing venture were 2 of the key assets of Maxwell Communications. The head of Maxwell Communications was Robert Maxwell. And within weeks after he disappeared from his yacht in 1991, it was discovered that his publishing empire was also underwater. And well, thanks to some of you. But you need to know that it was an empire that had 2 heads. London was where Maxwell's financial affairs were administered, but its principal assets, consisting of those things that I was just telling you about, were located in the U.S. Maxwell's sons, as his successors and heirs to the governance of the companies, filed a Chapter 11 case in New York where many of the company's assets were located. The following day, because there were also concerns about English creditors levying on assets in the UK, and also because under UK law, directors of an insolvent company may incur liability for trading while insolvent, Maxwell filed a petition for an administration proceeding in England. And the administrators, who are something like our trustees, were appointed. The administrators ousted the sons and took control of the case and of the management of the debtor. And at that point, they could have dismissed the U.S. case, or they could have converted it, well, they couldn't have converted it to a Chapter 15 because it didn't exist then. But they could have converted it to an ancillary case under Section 304. But apparently they decided the 2 cases were better than one, and they let the Chapter 11 case continue. And no doubt also they suspected that they might have to invoke the power to reject executory collective bargaining agreements and possibly the power to avoid preferential transfers, and they might want to invoke U.S. law to do that. In the U.S., Bankruptcy Judge Brosman appointed a special examiner whose mandate was to harmonize the two proceedings so as to permit a reorganization under U.S. law that would maximize the return to creditors. The special examiner and the London administrators agreed to a protocol, and you'll hear the word protocol from time to time, that allocated functions between the two courts and provided for cooperative administration. The protocol was approved by Judge Brosman in New York and by then Mr. Justice Hoffman, now Lord, in London, and it became a law of the case. The protocol provided the two primary goals should guide the UK administrators and the US examiner, and those goals were maximizing the value of the estate and minimizing waste and conflict. The protocol recognized the UK as the seat of corporate governance of the business, but it provided that major decisions such as borrowing, selling assets, and filing a plan would require the consent of, or at least consultation with, the U.S. examiner, and in some cases the approval of the U.S. court. Hearings were held on closed-circuit TV. Ultimately, this resulted in a reorganization plan that was voted on by creditors in both countries, and about $2 billion in assets and $4 billion in liabilities were involved in the case. And it was, for the most part, a very harmonious case. The only material conflict that arose, and it's the subject of the Maxwell opinion, was whether U.S. law or UK law would govern the recovery of preferential transfers that had been made to French and English banks. Prior to the filing, Maxwell raised money by selling over $300 million in assets that were located in the U.S. The proceeds of the sales were used to pay debts owed to those foreign banks. When the UK administrators announced their intention to bring the preference action in New York, the banks went a little nuts because the elements of a preference are much easier to prove in the U.S. than they are in the UK, where, among other things, intent to make a preferential transfer has to be shown. How did it get resolved? Well, while Mr. Justice Hoffman was on vacation, Barclays Bank asked a different UK judge, who was not a signatory to the protocol, to temporarily enjoin the administrators from bringing the preference suit in the U.S. court. And that judge entered the dreaded anti-suit injunction. Later, when Mr. Justice Hoffman returned from vacation, and the bank asked him to continue the injunction, he declined. And here's what he said. The normal assumption is that the foreign judge is the best person to decide whether an action in his own court should proceed. A decision by the U.S. court to assert jurisdiction would not, in my judgment, involve, according to English notions, so egregious a claim of extraterritoriality that justice requires that it should be prevented by injunction. It seems to me, therefore, that an injunction, were I otherwise disposed to grant it, could serve no purpose except to antagonize the U.S. court and prejudice the cooperation which has thus far prevailed between the Chapter 11 and the English administration. If the U.S. judge does not think that there is a sufficient connection with America to justify a preference action against Barclays, she will dismiss the suit. And that's what Judge Brosman did. She concluded that the center of gravity of the transfers was London, that the expectation of creditors was that English law should apply, and that the wholesomeness of the transfers should be decided by an English court under English law, employing what Neil might agree, and Hannah might agree, and Aaron Torsky would agree, if he were still with us this afternoon, kind of a classic conflicts analysis. And I'm going to stop there and turn the microphone over to Eric.
So before I proceed to the few slides, let me start by placing my paper in the context of the other papers, especially as we're nearing the end of this conference. And thank you, Brooklyn and Ted, for... Where is Ted?
I'll accept this next.
Okay. For inviting me to this so well organized and until thus far, at least, a very interesting conference. So my paper follows the universalist approach. I'm not agnostic about it. I'm a universalist atheist. And so it is in line with J. Westbrook's One Law, One Forum universalist approach, also in line with the universalist sentiment expressed in Leif's article. But I argue that in the context of groups, we need more nuanced solutions, not because there's a problem with universalism, but because groups come about in very different structures, and in some scenarios, they won't need any universal solution at all. And one of these nuances is this concept of taking account of local priorities, and in this sense I follow the virtual synthetic approach of John and Ted, but in a more limited way. So I wouldn't call it virtual or synthetic, because I wouldn't adopt or transplant the whole local process into the main proceedings, only have regard to local rights, and only in groups of certain types, and I will explain later. I acknowledge, and I'm in line with the pragmatic solutions that were developed in the practice and stressed in Gabriel Boss's paper very forcefully and convincingly, but I'm skeptical about the future of these pragmatic solutions in view of the revised EU regulation. And with regard to the model law, as I mentioned earlier, I'm hopeful that the working group will take an additional incremental step, and in this respect I adopt Jenny's approach, incremental step, but an ambitious one that will go in the right universalist direction and fill in the gaps, including the choice of law issues that need some more explicit rules, as also suggested by Judge Groper. So my paper is based on some assumptions, and if you disagree with these couple of propositions, then you wouldn't agree, or you shouldn't agree with the rest of my suggestions in the paper. And the first one, as I mentioned, is that universalism is the better approach for cross-border insolvency, and I wouldn't reiterate why. The idea is that in cross-border insolvency, we should centralize the proceedings in the home country of the debtor, and the law of that home country should apply, subject to very limited exceptions, and I would limit these exceptions to the maximum extent possible, and also subject to public policy circumstances. But group structures do vary, and so the extent to which we will need a universalist solution may depend on the particular case. And the second proposition is that when determining a private international law question, jurisdiction, applicable law, the primary factor or the primary concern is with connection between the debtor and the jurisdiction with regard to the jurisdiction issue, and then the choice of law, the applicable law question, follows the jurisdiction based on the universalist lex concursus solution. We may take account of agreements between the parties, but the main concern is with connection, and this is also linked to some extent to reliance and expectations, or expectations and reliance is an element of this connection-based approach, and this approach should apply to groups as well, in the same way. In other words, I'm less concerned with regard to private international issues with the corporate form, with lifting the corporate veil. I'm looking at the debtor as my subject matter, but the debtor may be linked, may be connected to a particular jurisdiction through its affiliation with another affiliate, with another subsidiary. I am less concerned with lifting the veil. I am concerned with lifting the veil and corporate form with regard to other issues. For example, whether to impose liability on the parent company with regard to the debts of the subsidiary, or whether to substantively consolidate the assets and debts. Not only because of opportunism, but also because I want to encourage commerce and reduce transaction costs. So I can't presume that assets and debts are mixed together. If they are mixed together, then I can impose substantive consolidation, but I won't presume that this is the case. But this is outside the scope of the paper. The paper is about private international issues and the fact that I place the proceedings, the insolvency proceedings with regard to a particular affiliate in the jurisdiction of its parent because of the connection between them doesn't say anything about liability and subsequent consolidation. It only says that this particular forum would preside over the process and perhaps would also apply its laws. But the veil is not lifted unless there are other justifications. So based on these bearing these two propositions in mind, universalism, different structures, and a connection-based approach to private international issues, let's look at a number of scenarios, situations that are relevant to the private international law question. So I didn't put here all the possible situations that may be relevant to other questions, for example, to the question whether to consolidate the proceedings. That question, in my view, would depend on the level of integration. So this isn't here. This is outside the scope of the paper. Here I presume that there is some level of integration between the entities, and I focus on the level of centralization for the purposes of the private international questions and specifically the applicable law, which is the theme of this symposium. And so in the first situation, I'm looking at the centrally controlled enterprise group, the one that was controlled from one head office, a single head office that managed all the relevant entities, and all these relevant entities are sufficiently linked or mostly linked to that head office. This is the COMI of those entities, the management of the enterprise group. In this situation, I would treat this group for private international law purposes as I would treat a single company with branches. Only for private international law purposes. I wouldn't substantively consolidate the proceedings unless it was a very integrated group, and I'm not talking about that. But for private international purposes, I would treat it as a single company, namely, I wouldn't derogate from universalism. So the law, the head office forum would preside over the proceedings, and the law of that forum would apply subject to the very limited exceptions and public policy circumstances. But when the group was to some extent decentralized, we need more nuanced solutions. And so in many cases, groups would be decentralized, but still will have a coordination center. So still a single head office that would coordinate strategically the enterprise, a single business, and sometimes the difference between the first situation and the second would be very subtle, and sometimes some entities would be centrally controlled and other more decentrally controlled. But we're talking about a situation where we have a single coordination center, and at least some of the entities are sufficiently independent and they have their own head office, their own COMI. In this situation, I would also look at the insolvency objectives, whether or not we need a universal solution in this situation. And in the second situation, I focus on the scenario where a group-wide insolvency solution is not required. So what is envisaged for the particular group, and possibly because the entities were so decentralized, and therefore separate organizations would be the most appropriate solution, or perhaps liquidation is the solution, piecemeal distribution of the assets, in which case we don't need a uniform group-wide solution for this group. We can open multiple proceedings in different entities' head office and perhaps minimally coordinate the process for the purpose of facilitating the flow of information, on perhaps considering a package deal of some of the assets, and we can do that through the coordinating head office, coordination center of this group. But in the third scenario, which is a very common scenario, and again, the difference between that and the first one could be rather subtle. In the third scenario, we still have the same type of decentralized group, or to some extent decentralized, but with a single head office that coordinated the entire business. And in this particular scenario, we do want to have a group-wide solution, a group-wide reorganization plan, global going concern sale, or even subsidiary consolidation because it is justified in the particular circumstances. In this case, we do need a universal solution, and we do have a connection to one single head office. Sufficient connection, although there is an additional connection of each of the entities, those that were decentralized, to their own head offices. So you have two levels of connections. And this is the case where I adopt the virtual or the synthetic, although I would prefer to call it I don't know, giving effect to local priorities. I use the word undertaking here, and I realize that perhaps that's not a good word either. But anyway, taking into account the local priorities in the context of this centralized solution. I'm not transplanting the reorganization process of the local proceedings into the main proceedings. The main proceeding govern, but they have to take into account local priorities because of this, to some extent, mismatch between the ex post insolvency solution and the ex ante expectation, or because there are two levels of connections, one to the main ultimate head office and the other to the local head office. The fourth and fifth scenarios are those cases where the group was totally decentralized. Perhaps it had several centers or just, several sisters or affiliate companies linked to some extent, coordinating their business via meetings of the board, discussions, and so on. But otherwise, there is no single center that we can predict in advance. In this case, again, if there is no need for a universal solution for the group, then we can just open multiple proceedings, and if needed, we can coordinate either from the different centers of each entity, or perhaps we could identify and even design a jurisdictional test which will be based on the identification of an approximate center, for example, in the entity which is the most economically significant, or in terms of its level of activities, assets, number of creditors, and so forth. In the fifth solution, we have the same type of group. It is completely decentralized, but we do want to consider a group-wide solution, in which case this approximate center could be the relevant center for the purpose of greater universalism or greater centralization, but this must be based on the notion of cooperative territorialism. So it must be based on agreement of the different jurisdictions and liquidators and courts. They need to agree to differ to the central forum. So in the first scenario, we apply universalism in the same way that we apply it to single companies. In the third, we also apply universalism, but we also take into account the local priorities. And in the fifth, it is cooperative territorialism. The second and the fourth do not require universalism at all. Again, not because there is a problem with universalism, but just because it isn't needed in the particular situation. And I highlighted the first and the third scenarios because these are the most common scenarios. In practice, most of the groups that would collapse as a whole will have some kind of centralized head office. Either would be completely centralized control, or they would have a coordination center. And this is also the solution that we should encourage and focus on if we agree with the concept that reorganization, going concern sales are preferable compared with piecemeal liquidations. These are also the type of solutions that were developed in the practice, the pragmatic solutions, as we call them. And I don't need to say much about it. We all know those cases, and there are numerous such cases under the EC regulation where the court allowed the opening of all the proceedings regarding the relevant entities in the same jurisdiction, and the law of that jurisdiction applied, subject to the same limited exceptions under the EU regulation. I want to emphasize that those undertaking cases, namely MG Rover, Collins and Aikman, were group cases. They were group cases with some decentralized entities. So the solution that was developed in the practice was not only pragmatic, but it was also justified. It is justified on the basis, and only if we agree with the concept of universalism as a preferred solution, with differences, considering different group structures, and the connection-based approach regarding the private international issues. We should also emphasize that these pragmatic solutions were also developed under the model law. And this is less emphasized in the academic literature. I did my bit, and Jay also mentioned that, but it's not enough, I think. It was developed also under the model law. We have a lot of model law cases, mainly between the US and Canada, but not only, where the recognizing court of the country that adopted the model law recognized as foreign main or non-main proceedings the opening of proceedings regarding several group members in the same foreign jurisdiction. And then they granted relief. So this allowed some degree of procedural or subsequent consolidation, depending on the case. And sometimes it was subject to conditions. So same type of solutions where we can either completely centralize the proceeding or centralize them subject to some conditions. In those cases where we have either centralization or decentralization, but still with a single coordination center. But as I mentioned, I'm skeptical about the future of these programmatic solutions. I'm worried that the revised EU regulation or the proposed new EU regulation will take us a step backward compared with those developments in practice. So the Commission is now proposing a new chapter for enterprise groups in the EU regulation, which is a good thing, to have a whole chapter for groups with explicit solutions, with explicit rules. But what does this chapter suggest? The Commission suggests that in case of groups, any group case, we will open multiple proceedings in the different jurisdictions and then cooperate. Now, this is excellent to cooperate, but of course, I can cooperate with you and by that fulfill my duty to cooperate under the new regulation and disagree with everything that you suggest. And the process could be painful and expensive. Perhaps not that painful for the lawyers, but it could be quite harmful for at least some of the stakeholders. So this is the novelty of the Commission proposal, to have a duty to cooperate between liquidators and the courts. The Parliament, that eventually agreed with this cooperative approach suggested by the Commission, added another novelty, and that's the concept of coordinating proceedings. So we will have multiple proceedings opened in the different jurisdictions, in the different member states, but also we could identify one. We can open coordinating proceedings either in the place of the decision makers or in the location of the entity which is the most economically significant, and there is no priority between the two jurisdictional tests. So we will open coordinating proceedings, and the coordinator will need to propose a plan, a coordinated plan for the group as a whole, which is not binding on the other jurisdiction proceedings. They may decide to agree with the plan or to disagree with the plan. There's also a new recital that is being proposed in the revised regulation that mentions that it is still possible to have centralized proceedings for group entities if we can identify a mutual commie for all of those entities. But this is only mentioned in a recital. It is not in the body, not mentioned at all in the body of the regulation, not mentioned at all in the chapter on groups. So the chapter on groups focuses on cooperation and the idea of a coordination, of a coordinator based on agreement between the different jurisdictions. So if we go back to that table, we can see that the Commission and Parliament approach mainly focuses or resembles the fourth and fifth type of solutions, opening multiple proceedings, applying multiple laws, and then also identifying possibly a coordinator either in the coordination center or in an approximate center without telling us which is the better jurisdictional test, and then proposing a plan, even though perhaps it's not necessary, and then the other jurisdiction will decide whether to abide to the plan or not. So cooperative territorialism for all type of groups, subject to that recital, but this is just in a recital, and it seems that parties will look to this chapter for the solutions for groups and will be encouraged to open multiple proceedings and engage in all kinds of negotiations that could be quite expensive. Ancestral, I think that the initial preliminary agreement of the working group to continue its deliberations with regard to the development of the model law with respect to groups is a very important opportunity to continue developing the model law in a universalist, incremental but ambitious way. And I'm more hopeful in this respect because it's a second round of the working group attempt to develop a solution for group. We already have some recommendations in the legislative guide. There is some acknowledgement that these recommendations perhaps are insufficient, at least with regard to the cross-border insolvency aspects, and therefore we need to consider perhaps how to transform these recommendations into a model law and also further develop the model law core concepts on access, recognition, relief, and see how they can apply to group cases. Thank you.
Good afternoon, everybody. Can I take this opportunity to correct the heading of my paper, which at the moment looks as if I'm at a different conference? It should say Group Insolvency, Choice of Law and Forum, which brings me, I think, into line with the discussion everybody else is having. Just in the time that I have, I'm going to focus on the highlights of my paper, or at least what I think are the highlights. You might disagree. The paper deals with what I would call the triumph of English pragmatism in this area of law, particularly in the European Union, but also, I think, recently under the model law in the States as well. Last night at a very pleasant dinner, John Potto suggested that my paper was triumphalist, and he was absolutely right. So first of all, why pragmatism? Insolvency, I think, is a practical subject. I'm always fascinated by listening to academic discussions. And now that I'm a part-time academic myself at Oxford, I have to actually get stuck into various theories and things of that sort. And there's some interesting American theorists on the reading list for the course that I'm teaching, which I've struggled with and tried to understand. But essentially, as I say, it's a practical subject. Solutions, for me, have to work. And for me, the law generally, and insolvency law in particular, is a tool. It's not a master, it's a tool. It's a tool to be used to get the just and proper solution that makes commercial sense in a particular case. I gather not everybody in this country or even in England actually agrees with that approach. Now, I would suggest a simple pragmatic proposition to begin with. If a group of companies is run prior to insolvency from the headquarters of a group or a subgroup, as often happens, like a European subgroup, I would suggest it can best be rescued, reorganized, or even sold as a going concern from the same place as the place where it was run from prior to the insolvency proceeding, once it enters an insolvency proceeding. So liquidators, administrators, debtor in possession, whoever can and in my view, ideally should continue the management and the operations of the group and the group companies from the same place, rather than have the disruption of, for example, having 20, 30, 40 different proceedings, possibly in different countries, different administrators. Some places like Germany, you do very often get different administrators, even in the same country, for group or companies in the same group. Now, this sort of idea of how to deal with groups led to the development of an approach to the finding of COMI, Centre of Main Interest, which is the key jurisdictional criterion under the EU regulation, of a test that I like to call the head office functions test, because that was my phrase. Professor Fletcher calls it the command and control test. That's probably more respectable because he's a proper full-time academic. The idea is that COMI will be located where the head office functions are carried out. And that's not always the same as the nominal head office or headquarters. It's where the functions carried out, where the actual administration, the actual running, the actual control of the business happens. Now, this concept was originally invented, and I claim some credit for that, in a case called Enron Directo, quite early on in the life of the insolvency regulation in Europe. And what had happened there was a very simple situation. As part of the Enron group of companies, a particular company called Enron Directo SA had a day-to-day business in Spain, I think selling electricity or something of that sort, and it was actually run and controlled from the subgroup, the European group headquarters of Enron in London. And on that basis, we went to court in England and opened a main proceeding in England, which is what we wanted to do, on the basis that COMI was located there. It's always easier to start this kind of theory and this kind of case without any opposition. And we of course, went ex parte, and there was nobody else there to argue the contrary. But as is counsel's duty under the English system, of course, I had to draw to the judge's attention any case law that was to the contrary. Fortunately, at that time, there was no case law, or indeed nothing was really written that was to the contrary. Bob Wessels came along later as the major critic of the head office functions approach, but I wasn't able to cite anything of his at the time. Now, I'm just going to underline some of the key points, as I say in my paper. First of all, this triumphalist thing about the head office functions test. First of all, in the European Court of Justice itself, as you may know, in England, in fact, in all the 27 or 28, forget how many there are now, EU countries, minus Denmark, which is still not in the regulation, judgments of the European Court of Justice are binding and have to be followed in preference to any local law, appellate or otherwise. The key case here is one called Interedil, and if I had time, I could amuse you with the sort of comic opera facts and procedure. But it's one of those rare cases where the facts can only confuse you if I tell you about them, and don't particularly help. And the procedure before the European Court of Justice, ECJ, being of the nature where they answer a preliminary issue. They give what I suppose here might be called an advisory opinion. So it doesn't actually matter what the facts are. That's the problem of the local court at the end of the day, if they have nonsensical facts, as they did in this case. One of the significant nonsensical facts was that Interedil, by the time it got to the first instance court in Bari in Italy, didn't actually exist according to the facts as found by the court and sent to the European Court of Justice. But the European Court of Justice was not put off by the fact that Interedil didn't exist, and held, I think, in what I would call a very sensible, pragmatic way, that the COMI of a company which doesn't exist, to find that, you look at the last place where it existed and see where COMI was at that point. Otherwise, you just give up your hands in horror. And one of the nice things about COMI is that, unlike every other type of concept, every company has a COMI somewhere. So there is a kind of residual default position. You have to find COMI somewhere. You can't duck the question. So the ECJ dealt also with the relevant criteria for COMI, and it's the key case on that. And they dealt with situations, for example, where there's a presumption based on the place of a registered office, and you're trying to rebut that. But they also dealt with a situation, whereas here, the ridiculous hypothesis was that this company had been registered in England, which it clearly hadn't, and it was an English company, but had ceased to be registered in England, therefore ceased to exist. So the question was, what was its COMI when it ceased to exist, having existed in England, which is clear from the facts it didn't. But just going with the assumption, they held, well, there's the presumption, registered office. And the question then is what I would call either the command and control or the head office functions test. And they don't quite use those words, which is a pity. But they talk about, quote, the company's actual center of management and supervision and the place of management of its interests. So that's pretty close to what I would call a head office functions approach. Now, although Interedil itself was not a group case, the approach to COMI in Interedil is of critical importance to groups. And the reason for that is the point I was making earlier, the pragmatic point, that you want an approach to COMI under which you can continue the management of the company now in insolvency and now perhaps trying to do something different but still very significant from the same place. In the case of a series of group companies, if you can find that all their COMIs are in the same location. And of course, if the facts are not that good, you can sort of help them along a bit before you file, which is sometimes done. And I know the Second Circuit here has warned against manipulation. I'm not actually sure what manipulation is in this context. I mean, to me, it's getting your facts right before you start. But that obviously shades into manipulation at some point, which don't entirely understand. But anyway, so for the purposes of groups, this approach is right. And it follows, although in the sort of tradition of the ECJ it doesn't cite, a long list of first instance cases in England, in France, in Germany, and in Hungary, all of which are in an obscure footnote in a little green book which has my name on it, and which is no doubt accessible in a well-run library such as that of Brooklyn. So I want to move now to the second point I want to highlight, which is a really important part, and that's head office functions test arrives in the US, like many other European immigrants. I just want to distinguish for this purpose two different functions of COME. It's a very different function under the EU regulation on the one hand, and under the Model Law Chapter 15 on the other. Under the EU regulation, the function of COME is to determine the allocation of international jurisdiction between different member states of the EU, who has the right to open main proceedings. The function under the model law and under Chapter 15 is different. It acts as the key criterion for recognition as a main proceeding, and in a kind of indirect way that influences where jurisdiction is, but doesn't control it. That difference has had a very important effect on the question of timing. In Interredil, it is clearly established and stated that the key time for judging where COME is, apart from this little quirk about if you don't exist, it's the time you last existed, leaving that to one side, the key time is when you file for your insolvency proceeding. Whereas in the US now, according to the Second Circuit in the Fairfield Sentry case, Morning Mist Holdings and Chris, the key time is the time that you apply for recognition, you file your request for recognition. And that, I think, it's a neat solution to a problem I don't have time to go into, that of offshore recognition, offshore insolvencies. So it's a neat solution to that, and I think it is justifiable, although perhaps a little surprising, undoubtedly surprising to academics, but very practical and pragmatic. It is perhaps surprising, but it works and has largely solved that difficulty that we had. But the other important part of the Fairfield Sentry case is that it also signals the arrival of what I call the head office functions approach to COME in the United States under Chapter 15. Now, for those of you not familiar with the case, Fairfield Sentry was the largest feeder fund for the Madoff Ponzi scheme. When Madoff was arrested, Sentry's two independent directors suspended share redemptions and focused on winding down Sentry's business and preserving the assets in anticipation of the inevitable litigation and bankruptcy. Board meetings were initiated by Sentry's registered agents in the British Virgin Islands, where Sentry was registered. There was correspondence with shareholders about measures that were being taken. That was issued from Sentry's address in BVI. And then the independent directors later constituted themselves as a litigation committee. And subsequently, the BVI court appointed liquidators in the British Virgin Islands and gave them custody and control of the assets. Then somewhat later, the liquidators applied for recognition under Chapter 15. And I haven't got time to go through all three levels of the case. The key point is that at the Second Circuit level, it was made clear that the critical time was when you file, but also in terms of where COME is. I'll just quote for you that one of the critical passages, for some reason located in footnote 8 of the judgment, it says, to the extent that the concepts are similar, a court may certainly consider a debtor's nerve center, including from where a debtor's activities are directed and controlled, in determining a debtor's COME. And then a bit later, they rely on the finding by the bankruptcy court itself that, quote, even though Sentry have assets in other jurisdictions, the administration of its affairs in the relevant time was orchestrated from the BVI, unquote. So it seems to me that the Second Circuit, again without using my favorite expression, which is rather a pity, but they do seem to have adopted the headquarters functions or command and control approach. The third point I want to underline is what I call avoiding secondaries, which somewhat shocked people when I first came out with this heading in a book. But this actually goes back to that rather large volume you were shown in 2007 that has an article by me, which made the point even then that where you have the opening of a main proceeding and you're engaged in some kind of rescue or beneficial sale in the interests of the creditors, and you've opened main proceedings for a number of companies in a group registered in different countries. In the actual precedents here, the case law precedents, these are countries in various parts of the European Union, continental Europe. Then the opening of a secondary in one of those European countries can be extremely disruptive to the process of controlling the whole group and rescuing or selling, and especially so, whereas often happens now, and many people don't realize this, but companies, and particularly groups of companies, often don't operate on an entity basis. They often operate on a cross-entity business basis, and therefore not being able to control the whole group from the same place can be very, very confusing if you're trying to do a rescue, reorganization, or a sale. And in that article in 2007, I explained the technique that had been used in the Collins and Aikman case, where the UK administrators went around the various European countries of which they were the main administrators of the companies registered, the group companies registered in those countries. And they said to the meetings of creditors, if you don't apply for the appointment of secondaries, and if no secondaries are actually open, which deals with one of Bob's problems from this morning, then we will respect your local priorities. And Collins and Aikman, the administrators were a little brave, one might say, because they went and made the promise without asking the court or even legal advice beforehand. So they then came to me and said, we've made these promises, how do we keep them legally? Because under Article 4 of the EU regulation, it says, cutting a long story short, priorities have to, as a mandatory matter, be decided under the law of the main proceeding. So I found numerous ways around that, which I don't have time to explain, and those were accepted, fortunately, by the judge. Again, helpfully, with no opposition in that case, arguing anything to the contrary, although, of course, again, one's duty as counsel was to point out all the potential legal difficulties, but the judge had no problem getting around them. Then the other case, Nortel, which is mentioned in my paper, and I think somebody mentioned MG Rover, which was another example of this, but that wasn't the case I was in, so I don't talk too much about that. Nortel, the administrators, had learnt the lesson from Collins and Aikman and came to see me first, and I said, we've got to go and ask the court first before you go around making these kinds of promises. And so we did, and we got the court's permission. Then they held the meetings of creditors, and it followed much the same path. But we invented a kind of refinement in Nortel, just to explain what that was. If you just read the EU regulation, you might think that any local creditor going along can just get a secondary open, providing he meets the criteria, maybe of an establishment in the secondary jurisdiction. But not so. The French, actually, who have adopted English pragmatism in a big way once they realized it could be to their benefit as well. In fact, in the Rover case, the Court of Appeal in Versailles actually declined to open a secondary on the basis that on the facts of that case it was pointless. It wouldn't help the creditors as a whole. It was unnecessary for the protection of local creditors. And there was no other good reason. So they actually refused to open a secondary. So there is an argument you can run under the EU regulation. There is no point opening a secondary unless it actually has a purpose. And this is, of course, one of the things the European Commission now want to write into the statute itself. Now, the problem that we came across was that believe it or not, it is not in every European country that the main liquidator actually has to have notice of anybody trying to open a secondary. Some countries you don't. And this, of course, is a historical relic that many countries' legislation have just not come into line with the new situation of the regulation. So we invented the refinement in Nortel that we persuaded the English judge to send out letters of request to all the relevant EU courts where somebody might ask for the opening of a secondary, asking the judge to make sure that the administrators in the main proceedings got notice of anybody trying to anybody trying to open a secondary. And I mentioned in the paper that anecdotal evidence suggests that some of the continental judges were a little surprised because they'd never come across anything like this in their entire lives. But none of them actually wrote back and saying this is rubbish or we won't cooperate or anything of that sort. And arguably it worked because there were, I think possibly with one exception, there were no kind of hostile secondaries. There are, incidentally, just as a footnote, there are friendly secondaries because occasionally local law, often Dutch or French law, where they have weird sort of employment laws that you might actually want to use in the interest of creditors and start a secondary. So occasionally we have started friendly secondaries. One in a case I think called, no, that's right, I think one's in Nortel and there's another one in another case I've now forgotten. Just a word on distribution of assets, and there's an interesting choice of law aspect to this. How do you decide if there's a dispute as to which assets are in the main proceeding and which assets are in the secondary? And then the supplemental question to that is, which court has jurisdiction? Does the main court have jurisdiction to decide which assets are in which jurisdiction, or does the secondary court? This actually has gone up as an issue to the European Court of Justice in yet another part of Nortel, and I'm involved in this, where this kind of issue has come up, where some employees in the French secondary have actually raised the question before the French secondary court. And on behalf of the main administrators, we're saying the French secondary court has no jurisdiction to decide whether assets are within the secondary or the main proceeding. It's only the court of the main proceeding that can decide that. There's nothing expressly set out at all in the regulation. I think there's nothing in the model law either about that. Okay, I'm going to skip to the conclusion because I'm out of time. Just to wrap up and sum up, what I suggest is that the head office functions approach to COMI has enabled a pragmatic solution to be reached in relation to COMI and groups. On such a test, it's easy to find that the COMI for group companies is centralized at the place where the group or subgroup's headquarters functions are actually carried out, as long as that can be proved by objective evidence which is ascertainable to third parties. Those are two requirements of the Eurofood case in the European Court of Justice. And that this enables a group to be rescued or beneficially realized after the start of proceedings, as well as being run officially before insolvency proceedings are actually started. So this has gone on so much that informally people talk about there being a group COMI, which is, of course, not a proper legal construct, but is a kind of practical way forward. We have the system of trying to avoid unnecessary and disruptive secondaries, which the French have picked up on, and we have the undertakings, which we've heard about quite a bit today, and have acquired this wonderful name, synthetic secondary. I hadn't known that John had invented that, because nobody told me in Brussels that he was the author, but it's an excellent turn of phrase now used by the European Commission, and very, very useful shorthand. And the Commission, as I say, are going to suggest that be legislated, although there are a few sort of purists like Bob who have found interesting technical and academic potential problems with it. But can I just leave you all by emphasizing and recommending a pragmatic approach to all these things, finding solutions in helpful ways. And really, it's a kind of collaborative effort. It has to be judges, legislators, practitioners, and academics all together, pushing hopefully in the same direction. Right.
Well, I'm afraid I may disappoint Professor Gerber, because I am going to try to make this a very non-academic conversation. And I'm going to sort of hijack the end of the program here, and I'm going to try to finish in about 15 minutes, so we have 15 minutes to have a dialogue. First of all, what I'm supposed to be doing is critiquing the two papers that you just heard. And because I agree with almost everything that was said, that's very hard for me to do. And in fact, that reflects, I think, a substantial amount of agreement on these issues around this table. And we all say it in different ways. But I think we are all generally in agreement that a single jurisdiction should govern the administration of business matters. That is separate from the substantive results. And I think what you're hearing around the table is perhaps some different ways of handling the need possibly to depart from a single law governing the substantive outcomes. Part of that is a practical recognition that various countries are going to recoil at having substantive results imposed on their local interests. And part of it, I think, is a genuine feeling that by having complex corporate structures, we actually embed in those structures different rights, different bundles of rights for different parties. And the fact that you have a commercial expectation in a particular jurisdiction when you're dealing with, in a corporate group, a local company, may in fact dictate that you should get a different result and perhaps have a different priority than someone who is in exactly the same position dealing with a company in another country. And so we're struggling with this problem, and we then overlay that with the fact that at UNCITRAL, where, what is it, there are 44 countries participating. How many do we have? 69. Now, yeah. So we've got countries who tend to view the idea that you would have, for example, a single court controlling and having that be either the nerve center or the center of decision-making or what have you, as being, shall I say, a somewhat imperialist concept, because the large global companies are managed in a relatively small number of jurisdictions. That's changing over time. But what we need to find out is whether, in John's words, we do have any normative alignment whatsoever between all of the countries who are considering this, and whether we've got a consensus view or whether we are just hopelessly unable to develop a consensus, which would imply we have difficulties dealing with corporate groups as well as even individual insolvency cases. So overnight, I was thinking about how we might go about trying to decide whether we can develop a consensus here. And what struck me is that a lot of the papers reach conclusions about where we should end up, but not how we develop a consensus to get there. And so what I was thinking about overnight was whether there is some sort of taxonomy about what we do as insolvency experts and what the insolvency system is intended to do, such that we could have a conversation on a more granular basis and finally define what the differences are. So I want to put the issue of groups aside for a second, because one of the big complications with groups is the fact that you've got Comey for a particular company that is controlling the group doesn't mean you have insolvency proceedings for the rest of the group, which gets you into the secondary proceeding problem, and it gets you into the question of, even if you wanted a single law to govern, how do you make that law impose results on people who don't want to go along in subsidiaries that may not be in insolvency proceedings, or if they are, have local regimes that apply. So let's talk about this in a more simplistic context, which is a single company with multiple assets in different countries, multiple creditors in different countries. And if you look at the different issues that we have to address, the first one is COMI itself, which country's court, if you were a universalist, and I think, again, as I say, I think there is some consensus on that, which country's court and which country's rules would you optimally have govern? The second is procedural rules. Which country's procedural rules would you have govern? Now, you may encounter some resistance here because you're going to get jurisdictions that say, well, in the grand scheme of things, we're universalists. It just occurs to me, I don't like your due process. And if you are the COMI, I'm not sure I want that to apply to people in my jurisdiction. And we can have a discussion of that. How far should you be able to depart from what one person says is due process and still have the procedural rules of the center of main interest apply? And that's worth having a discussion of. Then you get into what I call the meta-substantive rules. The meta-substantive rules are, is this a reorganization or a liquidation? Do we stay secured creditors from foreclosing on assets? Do we use their assets in the process? And what protections do we provide? What are the procedures for determining the amount of a claim? And the procedures for adjusting relative rights, like voting. Meta rules like, do you have an absolute priority rule which honors priorities under non-bankruptcy law, or do you depart from that? So you have these meta rules, and the question is, do we share a view on big questions like whether we should reorganize or whether we should liquidate, and which country's law should govern that? Then you get to the next level, which I call, there are two levels of what I call micro-substantive rules. The first one is administrative micro-substantive rules. There are rules about governance in the process. Is it a debtor in possession? Is it a trustee? Is it an administrator? And you might find a great deal of resistance. Countries that insist on trustees may not like debtors in possession. And we actually, when we were debating the model law, there was resistance on that issue for a long time. And that resistance actually lessened over time. So the dialogue actually accomplished something. There are also questions of asset administration as opposed to distribution. What approvals are going to be required in order to use assets in the ordinary course of business, outside the ordinary course of business? What rules are going to apply to the sale of assets? What rules are going to apply to borrowings? Again, not a meta rule, but this is a very important substantive rule because it affects relative rights. And do we all agree that one jurisdiction's rules should govern that? And then finally, what I call the entitlement micro-substantive rules, which relate to, do you recognize entities? What are your rules for substantive consolidation? How do you deal with contractual rights? What contracts can be affirmed? Which ones would be rejected? What are your rules regarding disallowance of claims? For example, what if you were accruing post-commencement interest? Is that an allowed claim in the proceeding? And finally, and most difficult, the whole question of priorities. And it seems to me that at some point in that taxonomy, you're going to stop short and say, we're reaching a point of resistance here. And we've got to start considering how we have not one law apply, but potentially multiple laws apply, and why, and whether it's because we think there is a reliance interest there, or because we simply think that, as with entities, it is simply commercial expectations. We will begin to identify the reasons we're troubled by individual pieces of the insolvency system and the idea that you have a purely universalist approach. And hopefully, there will be many, many issues on which we will have consensus. There will be some issues on which we have differences, and we're going to have to allow those differences to govern. And over a long period of time, I don't know how long, I suspect that eventually the pragmatic approaches that Gabriel is talking about will end up evolving into more systemic approaches. And I don't know if it's a model law that then gets passed in a number of countries, but we will begin to have at least a consensus on how conflicts in this area should be dealt with. And maybe it won't be in my professional lifetime. I hope it would be, but I don't, it's very possible it wouldn't. But on the other hand, we've got to start the dialogue because, as I said earlier, we are dealing with Gabriel's cases. We're trying to be pragmatic, but we don't know whether the courts are going to allow us to do what we need to do as a practical matter. And I left aside the issue of groups because it's even more difficult in a group context. How you can take solutions and impose them or even make them work where you don't have 100% of the creditors going along is a very difficult problem if you don't have an insolvency umbrella. So with that, I don't want to say anymore. I'd like to get the dialogue going because I think the ultimate question here is how do we get consensus? Thank you.
So to get the dialogue going, would any of today's earlier speakers, Christoph?
May I just add one more person in this context of the problems you were addressing, the legislator, because what you was saying about the introduction of the step backward in the new European regulation, that is a cooperation of the German guy in the ministry together who met his French colleague, and he just didn't like the concept of Gabriel, and for that reason they've just fixed it. It was a meeting in Berlin, not too far from my office and at the university, and they just decided that this is going to be the place. So in order to pick up what you said, Don, the communication has to extend. It has to include the legislators.
What are your thoughts about anti-manipulation rules on the corporate form? Does this context-based approach, is that going to cut it, the 10% or whatever? Wasn't there something about 10%?
Of cases where there was forum shopping? What do you mean? 10%?
I thought there had to be some. I thought that the Commission and the Parliament were disagreeing on what the anti-manipulation rule would be.
The 3 months.
Yeah. So what should the answer be to prevent? Give us a good academics approach from someone who's thought about this for a long time.
I have a completely different approach to forum shopping, and that is that we can deal with it via debtors and directors' duties rather than through the COMI, etc. So we can just have a center of main interests, COMI, a solution that will deal with most of the manipulation problems because we're looking at a place to which we have a real connection. So it's not contractual. It is based on connections, and therefore there is so much that you can do in terms of fixing the facts. You can fix them a little bit, but still you need to have a real connection. So that deals with that. To the extent that you actually fix the facts in a way which is abusive, and not all the fixing will be abusive. Some of it could actually be useful. And that's where the director's duties approach comes in, because when you did that, you fix the facts, you now have a new head office in a different jurisdiction. Now this court that needs to decide whether to open the proceedings in that jurisdiction need to look at this, the fact that the COMI moved at some point, the head office moved. One question would be, is it really the COMI? So did the COMI actually move? And the other question would be whether it was a manipulation by the debtor and perhaps other that collaborated with the debtors, so it could be lender's liability as well, whether they took into account the interests of the creditors as a whole. So I'm looking at it from the wrongful trading, English, now universal, ancestral, director's duties approach. If I actually moved, and I did that, considering the interests of the creditors as a whole, at the time approaching insolvency, then I'm fine. Then it's not manipulation, really. It's actually a useful move. It is based on COMI. It is also based on finding a jurisdiction with a better reorganization process.
And do you have any space for a contractual overlay on that or not?
In terms of the contractual, no. I would base it on connections. The only contractual element would be a cooperation between the liquidators and the courts post-insolvency. So insolvency commenced and perhaps in multiple jurisdictions, and then we need to cooperate and find a solution, especially in those totally decentralized cases where I don't have a single COMI. And then we need to cooperate and perhaps defer to one of the jurisdictions, but still I would do it within the choice of law framework. So you have to have some safeguards. You can't just decide that this is the best jurisdiction and we will apply the law of that jurisdiction and we'll redistribute rights in the process without considering what would be the effect on local rights. So I can cooperate, but in the context of my choice of law jurisdictional framework.
Can I give you a pragmatic answer? As far as I'm concerned, there's no, I'm not disagreeing with anything you said, but I think this just sheds a bit of different light on it. There's what I call good forum shopping and bad forum shopping. Good forum shopping is in the interest of creditors, and bad forum shopping is against the interest of the creditors or for some collateral selfish motive of the debtor. Factually, I've looked at all the cases, I've discussed this with the Commission, I've discussed this with a whole load of experts, including Bob in Brussels, when we looked at we were discussing the Commission's proposals. And what I think everybody agreed on was that factually, there has never yet been a documented actual case of corporate bad forum shopping. There obviously has been movement of the facts and so on, creation of facts, but they've always been in the interests of the creditors finding a more successful and better type of proceeding in the interests of creditors. On the other hand, there have been a small number, relatively small number, of individual bad forum shopping. Now, nearly all of these have been rejected on the facts because they nearly all involve either fraud or false evidence, or the change in the facts is not ascertainable to the creditors. So whenever these have been challenged by creditors, the creditors have always succeeded in setting these aside. So on the basis of that, I don't think there is factually, pragmatically, there is not a forum shopping problem. Because good forum shopping is going on, it's working. Bad forum shopping is being set aside where creditors object.
Yeah. I have one thing to add on this. One of the problems we face with insolvency law is that substantive rights are affected by forum. It's not just procedures. And that means that there are creditor groups who will look at their own position relative to everybody else and say, we'd like you to have another forum. And there have been loan agreements that effectively have mandated migration. That is something which, over time, the effect of that dissipates because people can adjust. But initially, it can be pernicious. And initially, it can be in the interests of some creditors and against the interests of others. So contractual solutions end up being the two parties to the contract figuring out how they can both benefit from the change. And in a collective proceeding, that's a problem.
But this point was raised by some of the experts in Brussels, and no one could cite a single example where this had affected any actual proceedings.
It's all anecdotal.
Judge Peck has been waiting patiently.
A microphone. Yeah. Thank you. Hello. I was kind of surprised as I was listening to the entire presentation as to how theoretical, aspirational, and unrealistic everything was that I heard. Is that too strong a statement? But I only came at lunch, so I missed them. And I guess one of my problems is that I approach this topic from having actually experienced a corporate group that dissolved suddenly and that broke up into separate cases. And we weren't talking about secondary proceedings. We were talking about 80 separate insolvency proceedings all over the world. And so to deal with this systemically, frankly, requires major reform And in my view of the world, there never will be a confluence procedurally unless and until there's a confluence substantively. And so long as we're dealing with the taxonomy that Don went through, and he saved the worst for last, but they were all pretty difficult to confront, we're really not going to get there, forget your lifetime, in the lifetime of the students. We need to do more if we're going to actually pay serious attention to the words we're speaking at this conference. And in terms of dealing with the problems of corporate groups, my own experience was I was the judge in charge of the command and control center of the case. I even used those words without citation because I thought they were mine. And you know what? Didn't mean anything. Territoriality trumped universality, and it will every time.
I think Professor Janger would like to reply.
I was actually going to ask a question, but I'm going to segue into it through what Judge Peck was saying. One question I have about using Lehman as a paradigm for what we're trying to do here is that Lehman was a particular kind of large group case in that, how should I say it, it was unplanned and it was a liquidation and it was to a large extent a belly flop, which was no fault of Judge Peck's. I think you were in a position where you had to make lemonade with a very bad situation. But in a lot of the cases we're talking about, but it was a case where the chips were falling all over the place and coordination was a rearguard action. In a lot of the cases that we're talking about, where you're getting into the case, coordination is something that has been given some thought on the way in and where the gains from it may in fact be greater. So it's not that there aren't a lot of lessons from Lehman, but I think it may be not the paradigm case that you want to have drive the question. But then I had a second question for sort of Don and Gabriel, which is, okay, sorry.
No, the only thing I was going to say, I actually think the Lehman case is a paradigm for cooperation. Nobody mentioned the multilateral protocol for cross-border cooperation. Did you, Simone? I missed that, sorry. And I think that that kind of ad hoc cooperation actually works. And the experience of Lehman, as I understand it, is actually quite admirable in terms of what the parties themselves did as opposed to what the judges did, wherever the judges were located. And I think it is that bottoms-up approach to cooperation that probably should be referenced more. I think that's where the future is.
Which actually, I'm glad I let you in because that actually was the segue I was going to work, which is we've been operating on three different levels today, right? Those of us trying to sort of come up with a set of normative principles and targets and broad sort of imperatives for the system, Jenny and Chris trying to think about how to legislate it. But at the end of the day, the data that drives the system is going to come from Don and Gabriel as the lawyers figure out how to make the practice work for their debtors in particular cases. So the question I was going to ask is, if we could pick one incremental legislative nudge that would push the cases in a direction that would encourage the development of cooperative norms and value maximizing norms, could you come up with one?
You go first.
Well, I'm bound to say this, aren't I? If you look at the EU regulation, there are express choice of law rules set out there, which are mandatory. They do have some extremely significant exceptions, but they're a very important start to treating, in this case, the world, rather than just the European Union, as if it were one closed group rather than a totally open group. And my one sort of cautious step forward, I think, would be for UNCITRAL to adopt into the model law the choice of law rules and also the deemed location rules that go with those for assets that are set out in the regulation. I hope that's a helpful suggestion.
I think actually I would look very much at giving courts authority to take settlements in affiliates and permit them to be binding on the entire case, because that's the pragmatic approach that Gabriel has been using, and it's not clear around the world that you're going to be able to implement those solutions. So it seems to me that where you're dealing with local assets and local creditors, and you've done something which as a practical matter perhaps achieves your result, that the court should have some authority to retain that result and make it binding.
Which court?
The main court, because the main court is dealing, trying to deal with the overall case.
Susan.
So a couple of quick things. Thanks, everybody. This was really amazing. A couple of quick things. Wanted to, I guess, agree and disagree with Judge Peck, since in this room I can do that. So, first of all, when you said that the harmonization of private international law rules or choice of law rules, or implicitly what you're saying is that harmonization of choice of law rules is not really easier than substantive rules, I would completely agree with that. I think one of the problems that for almost a century people have gotten into is assuming that somehow it's easier to reach agreement on matters of procedure than substance. But of course, it isn't if the procedural rules have substantive results, right? Which is precisely what is the problem with bankruptcy law. It's procedural, but it has substantive results. Now, what Ted was saying about, and differing with you about that we'll never have universalism, it's always territorialism, I hope you're not right. We're all wasting our time. Perhaps this is just a hobby for all of us, but not all of us. Well, a hobby in that we get paid. Yes, we get paid for this, but it's useless what we're doing, right? We may as well be baristas. It's more pragmatic, but I think that there is some place for universalism, particularly where the pie is going to has some hope of getting bigger. Where I think layman is sui generis, there are a lot of ways in which it's like every other case, but the way it was sui generis was that it was more zero sum than your ordinary reorganization. Pardon me? Nortel, yeah, even there the pie, you weren't going to lose, the question was, would we lose the pie? Got bigger, exactly. Even in Nortel. One final thing from a historical perspective, there was an enormous conversation that took place around the turn of the century about what the purpose of the codification of international law was. Was codification about restating practices that were occurring on the ground, which was pretty much Don's suggestion, or were we looking to develop or formulate something more universal and international that pushes the national ahead, kicks the can down the road, whether incrementally or in some big step? And I would say that the League of Nations was kind of stuck in only doing what was both desirable and realizable. And one of the big advancements of the United Nations was that they, not just UNCITRAL, but the International Law Commission more specifically, took on the possibility of doing modernization. Yeah, doing something more than that. There are pragmatic reasons for that. One pragmatic reason for that is because as soon as you wait for practices to ossify, to settle on the ground, and that's all you're codifying, you've really not codified, you've ossified, right? And you've prevented practices from moving forward, whereas instead if the international organizations, the national legislators, and the practitioners on the ground can kind of keep mixing it up in a kind of recursive fashion. I have to say Terry Halliday was kind of ringing in my ears a little while ago. Then maybe it's not perfect what we're doing, but we don't get stuck in the mud.
I just would like to soften my rhetorical flourish when I said that it would always trump universalism. The Lehman experience, I think, demonstrates that separate jurisdictions look out for their own, and that the administrators, trustees, and receivers appointed in the various jurisdictions that were looking after Lehman affiliates in foreign jurisdictions had one goal: to protect their creditor constituencies. The fact that we were able to work out a plan in which settlements were cobbled together demonstrates that universality can trump territorialism, but it's ad hoc, and only when it's in the perceived joint economic interests of all.
So can I respond to Susan? Or go ahead, Michael, it's your show.
Well,
Oh,
2 minutes. We're gonna cross borders very quickly to Missouri. And Chris Rudman.
Thank you. I just want to make one point, and that is that as entities, especially Ancestral, talks about these issues and education continues, I agree with Don's comments, there's progress. And let me give you just one example of one of the discussions we had on group enterprise. And this came up on a forum shopping issue. The Italians said because we have labor laws that protect our laborers and have very extensive benefits, that when companies move to the UK and there's a limitation on benefits, then those creditors are substantially disadvantaged as part of the process. And so there was an issue about whether we should have specific provisions restricting forum shopping as part of the process. That discussion resulted in the fact that UNSTRAL recognized, and the states recognized on a uniform basis, that the reorganization of a company was much more substantial and important than individual issues. And so the group itself, by consensus, even though it's to the adverse interests of some of the different states there, agreed that there should not be a limitation established in that regard, but that there should be a recognition that reorganization was much more important. Now, this is an important concept because when states realize and make determinations contrary to their individual interest, but for the good of overall, then that also, as an inroad, that work can be accomplished. And so I think that's just an important concept, that these ideas have changed and there's progress moving forward.
I'm going to let Don have the second to the last word, and then I'm going to turn it back to the big chair to sum up.
Okay. Well, Chris's comment is very related to what I was going to say in response to Susan, because I don't think we should be pessimistic about this. In fact, the way I would characterize what Chris said was not that they're acting against their own interests when they agree to something like what Chris described, but rather there is a larger interest that they're serving. And that will never happen in a particular case like Lehman Brothers, but in the context of having a dialogue, and I think in the context of going issue by issue, starting with do you reorganize or do you liquidate, but just going down the issues, you will find out where the interests are common. And you may be able to reach consensus on at least some things, and then understand why you have differences on others, and you begin to see the contours of a workable solution.
That's exactly the working method.
Yeah, exactly.
Okay. I'm going to ask for some applause for the panel. I, less than anyone else here, want to see this end. This has just been an extraordinary, and I like going long anyway, but it's just been an extraordinary day. I've been taking a lot of NyQuil, and I'm still sort of checking to make sure this isn't just a dream that I had. Because, yeah, it is. Because
You're going to wake up.
Yeah, I'll wake up. It didn't happen at all. This has been, I want to thank the panelists. I want to thank the audience. I think we've had a productive discussion, both as a matter of academic interest, but also that I think will help move conversations and practice forward. And so I really do want to say thank you to everybody for an extraordinary day. And I have to get 2 bits of logistics in. For those of you who are III members who want Bruce has asked for a small business meeting. We'll adjourn upstairs. And for those of you who are of the speakers who are joining for dinner, come so that I can give you logistical information. With that, let's consider the conference adjourned, and thank you all so much.